All right, this is what I'm going to ask you to do for me. Stop using words that have more than 3 syllables that are in no way related to the questions that are being asked of you. So here's the thing.
This guy walks into court sounding like he's trying to win a philosophy debate instead of a sentencing hearing. But underneath all these complicated words is a very serious accusation: armed robbery.
All right, we're back on the record in 2025 CR 012572-02. Michael Robinson. Can I have parties reannounced?
Michael DeLeon for Mr. Robinson.
All right, Mr. Robinson, you're still under oath, and did you have a chance to think about what you wanted to tell the court?
I did.
All right, do you need any more time?
No, no.
All right, Mr. DeLeon, you may proceed.
All right. Can you tell the court why you think you should get deferred adjudication?
Certainly, requesting a chance of external rehabilitation. That's to have an opportunity to be there for my children, all the women dependent on me, and you know, and evolve. You know, it is kind of limited, if I may, to evolve in such circumstances. Yeah, I have them, and did, but simply asking that of you understand that I have a very small record, if not minimal, you know, that of a misdemeanor, and I just feel as if I would pop the mirror, but I had qualified and deserved.
First, you almost feel bad for him. He's 21 years old, talking about his kids, talking about changing his life. But the problem is, the court isn't just listening to what he says. They're comparing it to what prosecutors say he actually did.
Yes, ma'am.
Okay, so you told the PSI officer you came to San Antonio in August of 2025, correct?
That is correct.
Do you remember the day?
I do not. Actually, that is incorrect. I said I came in July, a couple weeks before. If you were to see the PSI, I said I was sick for it.
So would it surprise you to learn that in the PSI narrative it says August? So is that incorrect then, I guess, is the question?
I guess that was improperly documented. I got incarcerated on August 9th.
Correct. Okay.
Or August 8th, one of those days. Okay. And yes, I was here a couple of weeks before, almost a month. So July is.
Okay, so you came to San Antonio in July then?
Somewhere around that time.
And you were living with your mom for a bit, right?
Correct.
And then where were you living after you stopped residing with your mom?
I was residing hotel to hotel.
Do you recall the names of the hotels?
I do not.
Did the hotel by the name of Best Value Inn sound familiar?
No.
Okay, so approximately August 2nd, 2025, you weren't staying at the Best Value Inn with Miss Santiago?
I do not recall.
Would it surprise you to learn that she rented 2 hotel rooms at that hotel?
It would.
It would surprise you. So it would also be surprising to you that you were seen on surveillance video with her going from room 222 to room 218?
Well, I would have to. I don't know what exact hotel this is, so I don't know exactly what you're specifying. But I understand that this is the step to this specific litigation. You're not talking about this transpired.
It's an incident on August 2nd.
Right. This is not the date of August 8th, therefore it is
right,
substantial within objectivity, correct?
But you're aware that you were alleged to be a suspect of a robbery of a similar nature on August 2nd with Ms. Santiago.
Judge, I'm going to object to the question at this point for the purposes of sentencing, only because he has pled no contest to the substantiated facts that are in the PSI. I don't see the relevance of the questioning for the purposes of sentencing.
Your Honor, the offense report regarding him being a suspect on August 2nd was included in the stipulations, and it does show that he had a firearm and was participating in the same not continuous, but the same course of conduct as the instant offense here, August 9th, 2025.
All right, so here's my question. The questions that you are asking him to commit to, are those for a different offense or this offense?
It's for an incident on August 2nd that mirrors the exact fact pattern as the August 9th offense that he pled no contest to.
It's not charged with any type of crime for August 2nd.
It's
So I don't find that relevant. Plus, it's the stipulations. He has stipulated to this, Your Honor.
All right. With regards to relevancy, that's going to be overruled.
This is where the case starts changing completely. Because now, prosecutors are suggesting this wasn't just one bad night. They're implying there may have been a pattern here. Hotel setups, planned robberies, and victims walking into traps. And once a judge starts believing something was planned beforehand, probation becomes much harder to justify.
Yes.
okay. Now I want to ask you, we found out a little bit about you, right? You have 2 children. Were you thinking of your children on August 9th, 2025?
Just argumentative, Your Honor.
Overrule.
You can answer the question.
Was I thinking of my children on this specific date of said transpirance was the question. Yes.
Okay, and did you consider how your actions might affect your children? Or I guess child, you had a 10-month-old.
I could have pondered furthermore.
That question hit harder than anything else in this hearing. Not because it was aggressive, but because it was simple. And sometimes the simplest questions expose the most. The court wanted one honest answer here, just accountability. But every response still sounded distant, almost rehearsed.
Correct.
What steps are you going to take to better yourself? Or what steps have you taken?
It is an internal switch in which I probably is just that of not partaking in ignorance, if I may. Subjecting myself to studies, sophisticating my characteristic rather than again subjecting to the nescience. That of we have 8 hours to be out within this predicament I am subjected to. And I have completely inverted my schedule just to stay up, study all night, and divert from things that are irrelevant. Such things those are substantial steps, if you ask.
I actually feel the judge trying to figure him out here. Is he nervous? Is he intelligent but socially awkward? Or is he trying too hard to sound deep instead of sounding honest? Because in sentencing hearings, authenticity matters more than vocabulary.
All right. I have some questions, and maybe the attorneys can ask it. Number one is, why are people continuing to have children and they don't have their life together?
I can't answer that for you, Judge.
And then number two, I will say this. With regards to this case, nobody has clean hands. It just depends on whether or not the public will be safe with his having probation. And based upon what I'm reading in the stipulations, I have some issues with giving him probation. And maybe somebody can alleviate my concerns, maybe not. Here are my issues. You have the complainant who meets the mother of your child and they're supposed to be meeting up some hotel to engage in certain intimacies in exchange for funds. And according to the stipulations, this was all planned out for you to come in and take money. And a gun is pulled on the guy. You want his gold chain. And in the stips, he said you even brought the equipment to determine the clarity of the gold chain. And he did tell the guy, hey, no, I'm not going to shoot you, but I will beat you with this gun. So I don't know if anybody wants to address those for the court, because I find it very concerning as far as it relates to public safety. And I don't know if anyone is able to address those concerns. And I know that the co-defendant, the mother of your children, is in Arkansas. She ended up in probation, and I know, but for her, this probably would have never happened, because if she wouldn't have agreed to meet up with him at a hotel, you know, to have intimacies with him instead of you all getting a real job and taking care of the children that y'all decided to birth into this world, we wouldn't be here.
Once the judge laid out the actual facts, the tone of the courtroom completely changed. This wasn't just jealousy. This wasn't some emotional outburst. According to the stipulations, this looked organized. A fake meetup, a robbery plan, a gun, and even equipment to check whether the jewelry was real. That's the moment probation probably started disappearing.
Steps. He says, I'm not going to shoot you, but, you know,
I'll beat you.
I'm paraphrasing. And, you know,
I mean, what are you shaking your head for? That's what's in the stipulations.
That is what the witness proclamated, Mrs. Boyd, but that is not.
All right, this is what I'm going to ask you to do for me. Stop using words that have more than 3 syllables that are in no way related to the questions that are being asked of you. So here's the thing. What's in the stipulation is what I go by, because stipulated means, you know, everybody agrees. If this person were to come into court to testify, they're going to say exactly what's in the stipulation. That's when people sign off on this, that's what they're saying. They're saying, you know what? If this witness comes in, they're going to say exactly what's in the stipulations. And when I review the stipulations, I'm viewing.
The judge laid out the actual facts. The tone of the courtroom completely changed. That's the moment probation probably started disappearing.
If that's not what I read in the stips, somebody correct me. I'm not going to take offense.
That is what is in the stipulation.
All right.
okay. Nothing further, Judge.
State.
Here, we ask that you deny the application for deferred adjudication sentenced to a cap of 6 years in the prison. Defense counsel points to the co-defendant getting 5 years deferred adjudication. However, it was Mr. Robinson that had the firearm and held the complainant at gunpoint. Further, the state would assert that Mr. Robinson does pose a potential risk of flight. Based on the PSI, he does have the 3 fail to appears in Arkansas. For June and July of 2025, which were dates prior to this and shortly before Mr. Robinson did show up in Texas, as he told the court. It's actually July of 2025, not August. So he does pose that risk of flight, and I don't think he would be a good candidate for deferred adjudication. He poses a risk to the community, Judge. We can't have people in our community going around holding people at gunpoint instead of getting jobs to financially support themselves in that way. So for that, we'd ask that you deny his application.
And lastly, Judge, on the court dates in Arkansas in July or wherever, it's all hearsay. We don't know exactly when those court dates are. We don't know anything about whether he was supposed to appear or not appear. If there's a non-appearance docket, we know nothing about that. So a little nitpicky on the state's interpretation of those dates, but the main big picture is this young man has never been convicted of a felony before. We're asking for deferred adjudication, Your Honor.
This is where the prosecution lands the final blow. Public safety, not his age, not his lack of felony history. The fact that prosecutors believed he willingly participated in an armed robbery setup. Once a firearm enters the case, Judges become much more cautious about giving second chances.
Next day.
All right, Mr. Robinson. Court is calling 2025 CR 012572-02 State versus Carl Robinson. Could I have parties announced for the record?
State.
Michael DeLeon for Mr. Carl Robinson.
And are you Mr. Robinson?
I am.
All right, so I did find you guilty. And I took an extra day just to consider whether or not I would grant your application. And I will tell you, there's a lot of things for a judge to weigh when they're considering whether or not to grant someone community supervision. Like sometimes people will say, well, you gave that person deferred. Why can't I have deferred? It's the same thing. But I try to stress to people that each case is individual, right? And there are certain facts in certain cases. Like, for example, I know part of the argument is like, well, the co-defendant got deferred adjudication. And I understand that potentially this never would have happened if she hadn't agreed to meet up with somebody, pretend that she's going to be intimate with them, and then they're being set up to be robbed. And I know that person doesn't come with clean hands either, you know, meeting some stranger at a hotel room. But in your case, the facts are that you went there and you went there with the intention to rob. This isn't something, according to the stipulations that I've read, this isn't something where you just happen to be there, you're upset that your girlfriend is agreeing to be intimate with this person. This was all set up for a robbery. And then in the stipulations, the guy says that you were trying to test whether or not his gold chain was actually gold or test the weight of it. So those are
The
probably
judge actually took an extra day before sentencing him, which means she seriously considered probation. But in the end, she kept coming back to the same issue. This robbery looked planned. And for the court, that changed everything. Not the speeches, not the vocabulary, not even the clean felony record. The planning, the gun, and the danger to the public. That's what turned this from probation into prison.
court will request the therapeutic community. Is there anything else with regards to sentencing?
Nothing, Your Honor.
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so I've retained jurisdiction. Your attorney knows what that means, but if you're coming back to me, you're going to have to show me something, and he'll inform you what I mean by that. All right, thank you.
Thank you, Judge.
All right, who's next?